Right, good afternoon, everybody, and welcome to Westgate Chambers Tea Time Training. Today's topic is Arbitrate, Don't Litigate. And you can see, just to avoid any hopefully technical issues, I've got my PowerPoint ready to go. I'm Elissa Da Costa-Waldman. I'm one of the senior practitioners at Westgate Chambers, and I specialise in financial remedies, TOLATA, and I also do a bit of children. But my passion is non-court dispute resolution. So that's why we're going to talk about arbitration today. Before we do that, there are some housekeeping matters that we need to cover. And I noticed that many of you, I can't see your lovely smiling faces because presumably you're doing lots of other things while I'm going to be talking, which that's absolutely fine. So if you want to keep your screens off, your mics muted, I'm very happy for you to do that if that's what you prefer. I should tell you that if you miss anything, this whole seminar is being recorded and it will be transmitted to the Chambers YouTube channel subsequently. If you have any questions, I'm more than happy to answer them. I prefer to have that at the end, please, because I'm not very good at going through my PowerPoint and looking at the chat at the same time. I can multitask in most things, but somehow not when I'm doing a presentation. So any questions, you can put hands up at the end. Very happy to do that. And I'm also happy if any of you, and I should say at the outset, I believe when we're doing any kind of teaching, educating, learning, whatever, there are no stupid questions. And this, as far as I'm concerned, is an indemnity insurance-free zone. But if you prefer and you don't like asking questions in a public arena, very happy to receive your emails. And I promise you, you may not get an immediate response, but you will certainly get a response. So if you don't have my email address, email the clerks. They will be able to let me know your questions and I will respond in due course, I promise. I've also got a lovely piece of news to share with you today. Some of us at Westgate have put together our own NCDR brochure. That will be going live very soon and it will be available on our NCDR webpage on our website. And I'm really happy about that because what it does, it's the brochure that tells you, so you can tell your clients or download it and pass it on to your clients, all the different types of non-court dispute resolution that there is and the benefits, the advantages of different types. But I'm going to be talking about not using arbitration for everything necessarily today. So let's get started and let's talk about arbitrate, don't litigate. So here we go. And wonderful. The first thing, my screen sharing is not working. And there we go. I've started with a brief historical background because obviously you can read this at your leisure, but we've come a very long way since before 1857, when really the law was very much religiously affected and influenced. And even when we get to the Matrimonial Causes Act in 1857, I don't recall personally, but I do recall reading that something like adultery was described as a serious matrimonial offence, almost as if it was a criminal offence. And I'll leave you at some point later to go through the historical evolution of matrimonial law. But we've come an enormously long way, I would say, in a fairly short space of time to get from religious influence, adultery being a serious matrimonial offence, to let's not even go to court. You know, we've got no fault divorce now. Everything has changed. And to the point where we can do things privately if we can agree to do that. And it often solves a lot of the problems for the clients. And I'm not talking about the case itself, but I'm talking about the emotional difficulties, the timing, all of that by using non-court dispute resolution methods. Some figures from the ONS, the Office for National Statistics. marriages are now increasing. The level of marriages went down. It's going up to pre-COVID levels now. We've got more and more couples choosing to live together. I'm seeing, and we're not just talking about financial remedies today, I'm seeing many more Talata claims. And until very recently, as we know, the only option for dealing with, I would say, the financial fallout from relationship breakdown, and that's just, that's marriages and people who live together, the only means of dealing with it was through the courts. And as we'll see, racing through this part of my tea time training, and before we get to talk about arbitration in more detail, the courts are not the best places. And I don't know if any of you have been listening to the radio or the news over the last couple of days, but there's a whole big issue about whether we should continue with jury trials and perhaps not, but leaving it more to judges to try and get rid of the backlog in the criminal courts. And we've got our own problems. We've got our own backlog in the family courts. So having the ability to step outside of the court process and deal with something that may, in some respects, be a little more humane for reasons that I will talk about, is better. It's much better. So what's wrong with courts? And you'll see everything, absolutely everything. We've all had that awful experience. Recently, I was at court in a Children Act case, private children, where we had three parties, mum, dad, guardian for the children. And it was most unfortunate that we didn't have a judge that day because the judge's husband had died. But the court knew they had to get someone else in. And they did get someone else in to take over her list. But unfortunately, that judge on that day had a funeral to attend. Now, I know that's very unusual. But two parties, the children's guardian and one of the parents, legally aided. So how does this work? So we all sat around at court all day, the three counsel, trying to resolve things so that the parties went away feeling they were spending their money reasonably rather than going away with nothing, no court order because there was no judge. But on that day, the judges that were present were so busy, they were not in a position to approve our order. Financial remedy courts, the cases that are financial remedies are often delayed because they're in the queue. They are not regarded in the court system as a priority. As we all know, in family courts, priority is really public law cases because you're dealing with children possibly being taken into care or in care and what happens to them. And then private law children is next in the hierarchy. And financial remedy is almost the poor relation. It's not a priority. One of the beauties we have, certainly in London, we've got the CFC and we've got specialist financial remedy units elsewhere. That's great. That does help alleviate some of the difficulties with the court system. There's also a new pilot, as you probably heard of, particularly in the north of England, dealing with more modest money cases. I'm not quite sure how that's going at the moment, but doubtless we will find out soon. But then we have other problems because if you're not in a financial remedy unit, if you're not in the CFC, if you're not in the north of England under the pilot, it is quite possible that if your case gets heard at all, it might be a judge that is not particularly well versed in finance, and the case goes a bit slower than perhaps you might hope if it gets heard at all. And I often get asked, as I did yesterday, about final hearings, can we choose our judge? No, sadly, this is not America. You don't get to choose your judge. You get what you are given. And sometimes you're not given the best judge for your particular case. The system doesn't work. Here's my favourite grumpy judge picture, because sometimes you get those judges and you can't blame the judges for being grumpy because there aren't enough judges. The people who work with these cases, who work in the courts, the judges, are becoming disaffected. We've got lots of bad-tempered, overworked people. They are under-resourced. There aren't many of them because the ones that are retiring are not being replaced. The court system's trying to save money, yet it needs to spend money to be able to do a good job for the people that we represent, and that is not happening. One of the reasons I think for the backlog, and it all relates to money, is lots of people don't want to spend money on lawyers, so we've got litigants in person. Not the sensible ones that will go direct access if they can't afford solicitors, but the ones who think they can do it themselves and don't know, unfortunately, what they don't know and don't know enough to be efficient at dealing with their cases. So it slows everything down. And we often, I think, have far too many FDRs in a list. You cannot expect a good outcome or a good indication when you've got a poor judge who's got 4 FDRs in the morning, 4 FDRs in the afternoon. Crazy. We've got other cases in lists that overrun because the courts may not have a completely clean financial remedy list. What about cases that take longer, cases that go part heard? The terrible stories, and I've had experience myself, where a court file has got completely lost. I'm not going to trouble you with the mood of the judge and what I call the Romford experience or the O'Dwyer experience, but they're stories, war stories, that when I get to meet some of you, perhaps over a drink or a lunch or a networking event, I'll tell you those. But certainly I have been in the CFC where at 4 o'clock in the afternoon, where I have a very equivocal and emotional client, I've got a judge telling me that you are hurtling towards a final hearing, Mrs. Da Costa-Waldman, if you don't settle this today, as if it's my fault. And I will not be bullied by judges. And, you know, I'm more than happy to say to a client, you don't have to settle it today if you don't want to. People need, particularly at 4 o'clock in the afternoon when they are already frazzled and it hasn't settled, to think they can step back and say, okay, I'll think about it. Maybe I'll settle it in a week, because that often happens. Now, I regard these days going to court as like going to an NHS hospital. You know, you get you're listed for 10:30, but you're there all day. And we know that. And it's not the most pleasant of experiences. And I think to some degree, there's a reason the court shouldn't be a pleasant experience. We want to put people off going. It's not a great place. Whereas arbitration is Bupa for lawyers, and not the NHS version. And I just think it has everything to commend it. And if someone said to me, so what are the disadvantages? Honestly, I can't think of any. And some of you are probably thinking, but isn't it more expensive? We'll talk about that. And I'll tell you why I don't think in the long run it is more expensive. For me, there is no contest. If you've got a choice of going to court or arbitrating, absolutely arbitrate. Yesterday, for example, I was on a sort of case management hearing in London on a Talata matter. We drafted a timetable, and the final 3-day hearing will not be heard before April 2026. Now, for people that have been engaged in trying to resolve it since 2022, that's not a happy situation. So we really do need to educate our clients, our lay clients, as to why this is a good thing, and get them to use it. So, the court-controlled timetable, we often find ourselves issuing proceedings because you've had that situation where you've been trying to negotiate since 2022, particularly with financial remedy. You write to the other side and say, look, sorry, we're gonna issue proceedings because we think, this is not a hostile step. We think we'll be better off with the court-controlled timetable. And you end up stuck with that timetable until your clients either settle at the FDR and maybe regret it in the morning, or they go to final hearing and we've all told them, do you really want to have a complete stranger impose a solution on you, which neither of you is going to like? And we know that the whole court atmosphere, the whole thing about it is just toxic. So what's great about arbitration? Well, everything. You get to choose your judge. There is a panel of qualified family law arbitrators, and they come from all backgrounds. You've got retired judges, you've got silks, you've got regular barristers like me, you've got solicitors. So there's a whole range of expertise, experience, and price, if you like. So, if you can't choose somebody from that range, I would be very surprised. Rather than turning up to court, as we do on an FDR, and finding a very frazzled judge who, as yesterday, thank you for sending in the bundle, Mrs. Da Costa-Waldman, but I'm so sorry I've not had a chance to read it. That's the last thing you want on an FDR. And I often wonder how judges on FDRs, maybe they've got not 4 in the morning, 4 in the afternoon, maybe they've got 6 for a whole day. To get your head round one set of papers is hard enough, but 6, you're very reliant on everybody's position statements. You can't really get stuck into one set of papers, and you've got to keep coming in and out of different cases. I think it's confusing. I think it's a lot to put on the judge. Whereas with the private arbitration, you've got one person who is yours for the whole time, not just for your actual hearing or your FTR or whatever it might be. I'm sort of straying into the private FTR, but let's talk about arbitrators. But that person is continuously and directly involved in your case from the beginning to the end. It's that judge that's going to give you directions. It's that judge that if there's blips, if there's things that you need a bit of help on between your initial directions and going to your hearing, they will be there. They are on tap and available. One of the beauties is the confidentiality, the adaptability, and the flexibility in the process. Often, certainly when I'm doing it, I will do directions, I'll talk to the parties, I'll see what works for them, because sometimes it might be an idea. They might want a remote hearing for whatever reason. We don't always have to do it face to face. We can consider the arbitration rules, but we can also look at making some of our own within that process. The whole thing avoids the delays that we have in court. It can provide a bespoke service, not the standardized service we get in court. And by avoiding that conventional litigation route and kind of working with the arbitrator to arrive at something that is going to suit the clients by way of process, you get speed, you get efficiency, and because you get those things, your clients actually save money. It's a really versatile way of dealing with things. You can have people in dispute, even in mediation, something, and take them out of it to resolve a discrete issue and then go back to resolve everything else in mediation. Where people can't agree, where they've reached an impasse because they've tried the other methods, this is where you have somebody, I think, with compassion, courtesy, and knowledge and experience to resolve it for them, but in a good way, not in the sense of that stranger on the bench when we think of the judiciary, but somebody that you have recommended to the parties, that they've been able to look at their CV and choose them, and that they've already met them in the directions appointment. It's got something about it that is humane and dignified in a way that I don't feel court is these days. And you still have the finality and the enforceability that you have with litigation. So, as I say, I can't see anything wrong with it. The other good thing about it, it promotes agreement before you get to engaging in the process, and I'll tell you why, but we'll come to that later. Let's think about who should use arbitration. And for a lot of people, I think when it first came out, it was, oh no, it should only be the sort of high net worth cases. No, in fact, it's probably a quicker, simpler, safer, cheaper option for not the high net worth. You know, let the high net worth people go to court. They can afford it. They can afford to wait. They've got loads of money. People that want a quicker way so that they have that finality and they know where they're going financially and they get that peace of mind, this is for them. It can be for your high profile clients if you have them, because they don't want the paparazzi following them around every time they go to court. It's not nice. So people who want privacy, confidentiality, arbitration is the key. People who, for other reasons, they're not necessarily high profile, but they have other reasons for wanting to keep a dispute confidential. Often, if you've got somebody who's, you know, top banana in quite a well-known business, you don't necessarily want all their employees to know what's going on with the finances. That can be very destabilizing and actually produce a result within their business that you don't want and is unhelpful in a financial case. So those people who can't get to a decision themselves want somebody else to make the decisions, but absolutely don't want to hang about waiting for a judge. People who've, as I've already said, reached an impasse in other non-court dispute resolution methods. The discrete issue. I mean, for example, you may have an issue where they absolutely can't agree, and, you know, the basis upon which pensions are shared, or something else, some other discrete issue where they've done everything else in mediation or collaborative law, but they just can't, you know, get over that hump with something else. Come out of your collaborative, come out of your mediation, get them into arbitration, and then come back in. There is nothing that says you can't do that. And I think that's one of the beauties of modern non-court dispute resolution these days. We need to be flexible and we need to be creative. People who've already signed a prenup or they've got a postnup and they just need someone to give them a steer as to how that should be interpreted, go to arbitration. Don't waste time going to court. You might have a case that's got some nebulous points of law. There's no reason why an arbitrator can't resolve that. And as I say, people who want a speedy outcome at a time that they choose with a tribunal that they choose. How empowering is that? You know, they have made those decisions. They are masters and mistresses of their own destiny. I think that's wonderful. It's a flexible process. You don't have to have a hearing in a room with an arbitrator. It depends very much on the dispute. It depends on the parties. We all have those clients, don't we, who just want to have their day in court, just checking the time, want to have their day in court, want to have their evidence heard, want to see the expression on the face of the other person when they're giving it. Yeah, we've all got people like that. But let's be sensible. There may be a lot of cases, particularly the single issue where you've hopped out of another form of non-court dispute resolution because you've got an impasse or you've got something you just can't decide. Consider, is it suitable for a determination on paper? If it is, the likelihood is that will be cheaper and it may well be suitable for that. Very often, if it looks like we're going to a proper hearing, then I would give directions. The most arbitrators I know would give directions. It's appropriate to have a directions hearing just to sort of case manage the case so that you have an effective arbitration when you get to the day. And the directions can often be dealt with on a telephone hearing, as you would do in civil court. Why not? Can do it remotely, can do it on a Zoom. Again, why not? Your parties, if they want their hearing, they can have it wherever they want it and when it's convenient to them. How amazing is that? This really is bespoke and it really works. So if parties want a remote hearing because they want a particular arbitrator, but geographically it's not going to work, there is absolutely no reason why you couldn't do that remotely. And as I said at the outset, the parties do have a level of input into the procedure, provided that in discussions with the arbitrator, it can all be made to work. What types of cases are suitable? Almost everything, almost. So with finances and property, definitely your regular financial remedy stuff, Talata cases for sure. Talata cases really helpfully done in arbitration because you can wait so many months before you get your trial, as my client discovered yesterday. So finances and property, we can deal with child maintenance, we can deal with child arrangements, what we used to call residence and contact. We can deal with specific issues involving schools. We can deal with other arrangements concerning upbringing in terms of relocation, but that's fairly limited. We can talk about internal within England and Wales, and we can talk about relocation, but only to Hague countries. So it is a little bit limited when we get to children, but otherwise it's virtually everything that you would deal with in court in the ordinary course of your practice. When I said earlier, the great thing about it is there's no disadvantages, it's actually based on agreement. This is it. You need some level of consensus from your clients to start with. They need to do these three things. They need to agree to arbitrate, agree the identity of the arbitrator, and agree to accept and abide by the arbitrator's award. Why wouldn't you do that anyway? And I think it's great because you're starting off by getting a level of agreement. Whereas, with court, somebody's issued proceedings. It's not the other person's choice necessarily to land up in court, but they're stuck with it. And then you get stuck with a judge that, someone might like, the other person might not. Both parties may think they're horrible. This way you get to choose. And then it's not that difficult, is it, to say, okay, we're going to stand by the award? Because if you get a court settlement, most of the time, there's no appeal. Most of the time, the discretion is so wide, appeals would be quite difficult. And parties know the judge has decided we're stuck with it. So at least this way, you get a level of agreement before you even begin. How to choose your arbitrator. That's another course in itself, but there is the IFLA website, that's the link, and there's a hell of a lot of useful information on the IFLA website about the process generally, about the two different methods that, for children, for financial stuff. There are booklets that you can download for lawyers, for lay clients, and there's also a whole body of arbitrators in that website that you can choose from, which is it is a great resource. And if you're interested in arbitration, I would urge you to use it and to signpost your clients towards the IFLA website because it is fantastic. Then what happens next? There have to be forms lodged. There are different forms for different arbitrations, whether it's money or whether it's children. Arbitrators, each arbitrator will generally have their own terms and conditions that they will send out to the solicitors for the parties, and then you get to meet the arbitrator and you have that first meeting stroke case management stroke directions where that's the opportunity for regulating procedure. So children arbitrations. There is a form called an ARB 1CS. That's simply arbitration number 1, the form, children's scheme. That's it. That's all that means. And what will happen is generally the arbitrator will contact the parties directly to confirm the appointment. and then the appointment of the arbitrator, that is, and then the arbitrator will send out a formal letter of acceptance. That's when the process begins. And very much how it works, you've got to do your forms, is up to the parties together with the arbitrator. And as I've said, it could be documents only, it could be face-to-face, it could be video, it could be telephone. It's whatever it is, to be decided by everyone. One of the things that can potentially increase the cost of a children's arbitration is there have to be DBS checks on the parties, which I think is important. We need to know if there are any safeguarding issues. And then there is the instruction of an ISW, because unlike the court process, there isn't an automatic CAFCAS safeguarding letter or CAFCAS involvement, Section 7 report and all of that. So this is how we manage it with children arbitrations. But it works once it's up and going and off the ground, it works very efficiently. And I must say, I'm always incredibly impressed by the standard and the reporting of the ISWs that we use. Financials, similar form. It's an ARB 1 FS, and that stands for financial scheme. Your family arbitrator, again, your finance one, will contact parties directly to confirm the appointment. There's a formal letter of acceptance. The forms have to be done because they get registered with resolution. Resolution keep a record of how many of each type of arbitration. They just like to know how many are being done, because it was a pretty slow start when it started around 2012. And it's amazing to think that this process has been going for 13 years, but we still need to use it more. And again, similar process with finance as with children. And again, the arbitrator will facilitate the instruction of experts at a previous direction appointment, should that be necessary in a financial remedy case. Could be pensions, valuations, all sorts. Generally, one would expect, if it's sort of in place of court, that there would be a hearing with evidence in much the same way as you deal with courts. And the decision then goes to court to be approved by consent, so it can be converted into a properly enforceable court order, because an arbitrator is not a fully blown judge. And whilst the arbitral award usually stands, it's important that it's converted, particularly with finance, into an enforceable order. And again, even I think with child arrangements, but as I say in my PowerPoint, less so. I've set out here the arbitration award recital, because that's what you need. Now, very often when you go through that whole process of, you know, your D81 and all that business, I would not expect you to have to complete a D81 if you've got an arbitration award recital. The courts are generally, and doesn't this help the courts, and why wouldn't they be anything other than keen to ratify decisions made in the arbitration process? Really important, because clearly the court will know, if there's an arbitration recital, that the parties have chosen somebody who is qualified to make these decisions, gone through a proper process, and that the court, I wouldn't call it rubber stamping, but generally the court can regard the arbitration process as equal to the court process and almost rubber stamp the award, rather than necessarily, you know, going through all the other stuff that you would do if you just had a consent order sent in by the parties. So I think it is helpful to ensure that when you've got your arbitral award, you must send in a consent order with it, but make sure it contains the arbitral award recital, so the judge is notified, I can approve this because I know it's come from a good source. Case law. We are getting a body of case law building up, which is very supportive of the arbitration process as an NCDR process, and also in relation to appeals. I have to say that as far as calling arbitration a non-court dispute resolution method, it's kind of way at the end of the spectrum, because it's very much like going to court, but as I say, in a softer way, in a way that is less scary, I would say, for the parties, but equally serious in terms of outcomes. There is a right to appeal if someone thinks there's been an error or a serious irregularity. And before the fairly recent decision of Haley and Haley, it was really hard to challenge an arbitral award. And I think that should be right. But the process was governed by 3 sections of the Arbitration Act. Obviously, Section 57 is about the slip rule. Oh, was there a mistake? We're not too worried about that. But the 3 major sections was 67, jurisdictional challenge. Difficult, because if you've agreed who your arbitrator is going to be, shouldn't really be challenging their jurisdiction. 68 dealt with serious irregularity, and Section 69 was on a point of law. But I have to say, it was, if you read those sections within the Arbitration Act, the arbitrator would have had to have been seriously insane in their decision-making for an appeal to succeed under the Arbitration Act. It just was not going to happen. And this caused a bit of difficulty, I think, in matrimonial financial law. There was a quote from Sir Bernard Eder. Interestingly, I was somewhere with his brother last night, who's a dentist. And Sir Bernard Eder was quoted with approval by Mostyn in a case called J&B. And he said, to kind of support the arbitration appeals system at the time, that he said the general approach of the court is one which strongly supports the arbitral process. By way of anecdote, it's interesting to recall I was once told many years by Michael Kerr, former judge in the Court of Appeal, and one of the leading figures in the recent development of the law of arbitration in England, when I was complaining about an arbitration that I just lost and difficulties in the way of challenging the award, I told him that the award was wrong and unjust. He looked baffled and he said, "Remember, when parties agree arbitration, they buy the right to get the wrong answer. So the mere fact that an award is wrong or even unjust does not provide any basis for challenging the award or intervention by the court." Now, Mostyn, on that basis, concluded, and he was right in his interpretation, that meant that it would almost, an assertion that the award was wrong or unjust will almost never get off the ground. In such a case, the error has to be so blatant and extreme it leaps off the page. So this is why people rarely appealed arbitral awards, because they knew how difficult it was to succeed on an appeal. And as I said, you'd have to have an absolutely insane, bonkers decision. And even then, now you can see why we come to Haley, because if an award is wrong or it's unjust, that isn't really going to cut it in matrimonial financial law, is it? So Haley's developed this in a way that it decided that where the award concerns a financial remedy of the kind that comes under the, let me just go back, that comes under the type that falls within the Matrimonial Causes Act, and a contested application was made in order to embody it into a court order, it's open to the court to review the award substantively, applying the same test as it would in an appeal in a financial remedy case that had gone through the court process. Was the award wrong? Was it unjust? And does that arise out of a serious procedural or other irregularity in the process? So I think that is right. I think Haley made the right decision, because most of the previous arbitral cases, they're really about commercial decisions. And we're not dealing with you know, monolithic companies that can afford whatever decision they get lumbered with. We're dealing with people where it could have a serious effect if we didn't apply the same appeal procedure and give someone that opportunity. So I think that's really important. And I won't, we've got a few minutes, so I won't waste your time by reading the Haley decision, but these are the major paragraphs. And I think what's important in saying what they said was wrong with the appeal process under the Arbitration Acts, and yes, let's go with the way we do it in financial remedies. The judge did go on and say, in saying that, I would emphasize, I don't want anyone to think that I am in any way undermining the arbitration process or the fact that parties have signed an ARB 1 FS. He says, on the contrary, people have to go into it with their eyes open and to understand that generally, all other things being equal, the award made at the end of the process will be incorporated into a consent order, and that is your award, and you are generally stuck with it. And I think that is important. But the appeal process was made softer, if you like, more gentle, because we're dealing with people rather than commercial outfits. And there's more, and I'm not going to read it. I hate PowerPoint where you just have to read it. You'll be able to read it on the website. You'll get your handouts, whatever. But you get the reasoning. So Haley changed the law, and it doesn't remove the routes of challenge under the Arbitration Act, but it says that the routes under the FPR are simpler and generally would be used if one wanted to appeal an arbitration. Unlikely, very rare, very rare. It doesn't remove the ability to challenge awards on grounds of mistake or if there's a barter event, they are still available. And of course, Haley does not address challenges in Children Act cases or challenges in Talata claims. So we still have to wait, certainly for the Talata claim. LT and ZU, that does concern children. And the court did hold that the arbitral award was wrong, didn't make an order on its terms. And in terms of procedure said, similar, this is similar, we use similar means as we would if we were doing it under financial remedies. You can appeal and we don't have to follow the Arbitration Act sections. And then we've got G&G, another Children Act case. Parties agreed to go to arbitration, stayed the family court proceedings, and they had their usual, they heard evidence, there was an independent social worker, but mother's relocation application was dismissed and an equal shared care arrangement made. The local lay justices were, they had to hear the matter to incorporate it into a court order. But during the hearing, the mother said, I'm going to apply to have this set aside because I don't like it. Father opposed that application and it went before Peel, Peel J, famous and important financial remedy judge, who said there should be a hearing to address the absence of direct authority on the legal test and or procedure to be applied when there was a challenge in Children Act proceedings. But what he does is he says, you know, we have to do it as close as possible to the procedure that Mostyn's provided in his practice note, which is triage the case, decide whether the challenge has a real prospect of success. If you get through that gateway, then you proceed to a full review hearing. If not, the order incorporating the award and it's determined, you know, there's a determination made there. So he's really good, I think, Peel, and he's appended some guidance to his judgment. So that's worth having a look at in your copious free time. So as we approach the end, what are the conclusions? I think, and there have been very, very few appeals in the last 13 years that arbitration has been available. I think it works extremely well. I think for all the reasons that I've said, it can be quicker. It will definitely quicker. And because it's quicker, it can make the entire process cheaper in the long run. It's useful for the whole dispute, the substantive dispute, or a discrete issue when you're in other non-court dispute resolution processes. We can do it remotely. We can do it on paper. I absolutely cannot think of a downside about it. So that's really it. And I would recommend, and I'm going to stop sharing so I can see better. I would strongly recommend that if you have cases that are suitable, that you do use it. I think we've probably got 5 minutes or so. If anybody has any questions, I would prefer if you could operate the bit that puts your hand up if you'd like to ask any questions, because I'm not really good, even with these glasses, at seeing what's going on in the chat. So does anyone have any questions? Any hands going up? Well, you obviously know all about... Oh, who's that? Hi,
it's Trina.
Hello.
That was brilliant. Thank you so much. That was really informative. I've used arbitration a few times and I am a big fan. So I would agree with you. I just wonder if you can help in terms of if you've got a financial remedies case that needs a preliminary issue hearing. How does that work in arbitration? Does it just sort of get rolled up in one hearing and then the whole thing's dealt with at the same time, rather than you would traditionally have preliminary issue and then FDR, for example? I
would use the same methods that we would use if we were in court. And what I'm thinking of is as by way of an example, and it's quite a typical example, sadly, is where you've got a financial remedies case between husband and wife, and one set of parents has perhaps provided a gift or a loan or something by way of assistance to acquire maybe the former matrimonial home or other properties, and that's your preliminary issue as to what is the status of the contribution. I would very much want to have that done as a preliminary issue in the same way and not roll it all up into one thing. It may be that one could give directions that, you know, if the preliminary issue is resolved on day 1, you could go into day 2 and 3. But I think potentially once the preliminary issue is resolved, it is likely that in order to save a fully contested final hearing, the parties would have sufficient information to hop into perhaps another method of non-court dispute resolution, even if they just want to negotiate, having heard the outcome of the preliminary issue. So I think there is a downside to potentially sort of rolling it all into consecutive days. Does that help you?
Massively. Thank you.
Any other questions? There are no stupid questions. Hi, Keris, you're on mute if you wanted to say something.
Hi, I just gotten in from court now, so I have been listening on my journey home. So thank you. That was all really helpful. I can't say I've got any questions per se, but I think the things that you said are so true in respect of, for example, that initial agreement as to the arbitrator just engaging in the process. It goes further than that, because I think they are actually then committed to reaching an outcome.
Yeah.
And that, you know, that's certainly the experience that I've had in the operations that I've done. It's just like a very different mindset.
It is. And I think that's right. You know, once you can get those 3 agreements at the beginning, it's almost as if you flicked a switch.
Yeah.
And even though they are still in dispute, it has a different feel to it. It's somehow...
They're actually there to get it done. Not one of them has been dragged there, because they are both there. They're both consenting, and there is, like I said, it's more than just an agreement. It's a commitment that they've paid money and they desperately want a timely end to it. And I think the one thing that you've said, which I think, well, 2 further things, I think is so true, that economically, if it's signposted at the outset, then I'm with you. I think that you're definitely going to save money in the long run.
Absolutely. Yeah.
I think the difficulty is, and when I've been speaking to those who instruct me, it's on the cases where a solicitor's had the case right at the outset and the people are in that positive mindset and they want to get it done, and they haven't been in the unfortunate position, as you were just describing with your client, who's obviously been going on since 2022, and they're then on their last legs, they're running out of money, and they've sort of lost hope and faith. So I think certainly, I know we in Westgate have sort of been saying increasingly recently, if we see something at the outset that we think is ripe for NCDR or arbitration, it's obviously best to get on that bandwagon straight away. And then ultimately it's the empowerment point. And you, from your experience, taught me in terms of how bespoke you can make the process, in terms of the directions, in terms of how you tailor it to your clients. And I think that, again, if you're not on the process from the outset, you don't realise the level of control or empowerment that you as
and it's
amazing. Your clients have.
I would say we can make this suitable for all cases. And I'm thinking, you know, there are cases where you know, someone's saying there's coercive controlling behaviour. A good arbitrator will be able to deal with that. A good arbitrator will allow somebody to have their screen off if they don't want to be seen by the other person because of what's gone on in the relationship. Because it is bespoke, we can fix in some safeguards. You know, it's not like turning up to court where you've got special measures and a screen and it gets horribly messy.
No.
We can use this method. We can be on screens where someone's got, you know, turn it off if they don't want to be seen or see the other person.
Yeah.
We can make it as easy as possible. Court is not like that, far from it. And I think you're right that if all of you take nothing else away, take away this, that the earlier you get people on board with something like this, the better. And the more effective the whole thing is.
Yeah.
And I think I failed to say, but I should say, generally speaking, in terms of paying for the process, the parties would normally share the cost. So, you know, one person might be in control of the fees in the first instance because the other person just doesn't have any money. And I certainly wouldn't recommend litigation loans for it because we can sort of resolve it in the wash, in the award. So, yeah.
Brilliant.
Any other questions before? Sorry, Keris, I keep.
No. I was to say I had my camera off, so I still had my sunglasses on, so I've been walking so quickly. I'll mute myself now.
Is there anyone else who wants to ask any questions? Okay, well, I'm going to say it's 2.5 minutes to 6, and I'm going to say thank you all so much. I know that, you know, you've all been terribly attentive, and thank you, Trina and Keris, for the questions. And I'm just going to plug Westgate Chambers NCDR brochure again. It will go live very shortly. We'll let you all know, and look forward to seeing some of you in real life soon. Thank you so much.
Thanks, Elissa. Nice to see you. Nice to see everybody. Thanks for joining.
Bye, Elissa.
Bye, everybody.